Telefast Communications versus Ignacio Castro Sr. JR number 73867, February 29, 1988. November 2, 1956. Consolacion Bravo Castro, wife of plaintiff Ignacio Castro Sr. and mother of other plaintiffs, passed away in Lingayen, Pangasinan. On the same day, her daughter Sophia C. Crouch, who was then vacationing in the Philippines, addressed a telegram to plaintiff Ignacio Castro Sr. at Scottsburg, Indiana, USA, announcing Consolacion's death. The telegram was accepted by defendant in its Dagupan office for transmission after payment of. Consolacion was entered with only her daughter, Sophia, in attendance. Neither the husband nor any other children of the deceased, then all residing in the United States, returned for the burial. When Sophia returned to the United States, she discovered that the wire that she had caused the defendant to send had not been received. Plaintiffs filed for action at CFI Pangasinan for damages arising from defendant's breach of contract. The only defense of defendant was it was unable to transmit the telegram because of technical and atmospheric factors beyond its control. No evidence appears on record that defendant ever made any attempt to advise plaintiff as to why it could not transmit telegram. CFI, after trial, ordered defendant to pay the plaintiff. IAC affirmed CFI's decision but eliminated compensatory damages and exemplary damages, hence this case. Issues: 1. Whether petitioner company is liable for damages. 2. Whether petitioner company is liable for moral damages. Supreme Court held on the first issue, yes, Article 1170 of the Civil Code provides that those who in the performance of their obligation are guilty of fraud, negligence, or delay, and those in any manner contravene to the tenor thereof are liable for damages. Article 2176 also provides that whoever by act or omission causes damage to another, there being fault or negligence, is obliged to pay for the damage done. In the case at bar, petitioner and private respondent entered into a contract whereby, for a fee, petitioner undertook to send said private respondent's message overseas by telegram. This petitioner did not do. Despite performance by said private respondents of her obligation by paying the required charges, petitioner was therefore guilty of contravening its obligation to said private respondent and is thus liable for damages. This liability is not limited to actual or quantified damages. To sustain petitioner's contrary position in this regard would result in an inequitous situation where petitioner will only be held liable for actual cost of telegram fixed 30 years ago. On the second issue, the court finds Article 2217 of the Civil Code applicable to the case at bar. It states moral damages includes physical suffering, mental anguish, fright, serious anxiety, besmirched reputation, wounded feelings, moral shock, social humiliation, and similar injury. Though incapable of pecuniary computation, moral damages may be recovered if they are the proximate results of the defendant's wrongful act or omission.